with two issues. That is issue number 2 and 3. Issue number 2 being whether the public participation conducted was sufficient. Issue number 3 being whether certain taxes cited in the petition and as enacted by the Finance Act are unconstitutional. Starting with the issue number 2, whether the public participation conducted was sufficient. The petitioners assailed the Finance Act on the ground that there was inadequate public participation. We appreciate that public participation is the hallmark of constitutional democracy and a manifestation of the people's sovereignty. Article 10, Sub-Article 2A of the Constitution affirms public participation as part of the national values and principles of governance that must guide all persons, state organs, state officers, and public officers when making or implementing public policy decisions. Moreover, Article 118 provides for the participation by the people in the legislative process, and we cited that provision. The principle of public participation in the lawmaking process has been considered in many judicial decisions. The Supreme Court, in the matter of the National Land Commission, acknowledged the principle of public participation as a form of checks and balances on the various arms of government in the execution of their mandates. In British American Tobacco PLC, the Court of Appeal set out the principles of public participation. I will just cite a few of them. The first being, it applies to all aspects of governance, and the public, number 2, the public officer and or entity charged with the performance of a particular duty bears the honors of ensuring and facilitating public participation. Number 3, the lack of a prescribed legal framework for public participation is no excuse for not conducting public participation. Number 4, public participation must be real and not illusory. Number 5, public participation is not an abstract notion. It must be purposive and meaningful. Number 6, public participation must be accompanied by reasonable notice and reasonable opportunity. Number 7, public participation is not necessarily a process consisting of oral hearings. Written submissions can also be made. And the court went further to outline the components of meaningful public participation, which we have cited there. Whether the public participation exercise was sufficient to meet the test in the BAT case is a question of fact. There is ample evidence that the National Assembly invited citizens to submit and give comments on the bill by way of letters to various stakeholders and newspaper advertisements. Secondly, the invitations indicated the venues of the public meetings and the manner of submission of written memoranda on the bill. The National Assembly provided liaison officers for the meetings. We find that the manner in which the National Assembly proposed to conduct the public participation was not only facilitative but also reasonable in the circumstances. Further, we do find that the public participation exercise was real and not illusory or cosmetic, because in response to the invitations, various members of the public and stakeholders gave their views and comments, which were received by the committee. From the matrix of stakeholder comments and memoranda exhibited by the respondents, the views of the stakeholders and members of the public were considered, as some proposals were adopted while others were rejected. The public participation exercise was thus real and gave diverse stakeholders an opportunity to present their views on the bill. The petitioners complained that some of the submissions by the members of public were rejected without giving reasons. The enactment of the Finance Act is a legislative process, and in discharge of its legislative mandate, the National Assembly passed it. There is no express obligation on the part of Parliament to give written reasons for adopting or rejecting any proposals received from members of the public. Nevertheless, We think that in order to enhance accountability and transparency, it is desirable that the relevant committee, after conducting public participation, gives reasons for rejecting or adopting proposals received. Apart from the sufficiency of public participation, the petitioners complained that the National Assembly incorporated into the bill 18 additional amendments whose proposals were not subject to public participation. The proposed amendments were to the Income Tax Act, the Value Added Tax Act, the Excise Duty Act, and Miscellaneous Fees and Levies Act, the Kenya Revenue Authority Act, the Retirement Benefits Act, the Alcoholic Drinks Control Act of 2010, the Special Economic Zones Act, and the Export Processing Zones Act. The National Assembly Standing Orders 132 and 133 permit amendments to be made to a bill during the committee stage. And we have cited again the case of Pevans, East Africa, the decision of the Court of Appeal in that matter, where the court affirmed the position that Parliament has the power during the legislative process to make changes to a bill post-public participation. And I think it's important that I read this passage. It must be appreciated that after the National Assembly has heard the views of members of public and industry stakeholders on a bill, it is not precluded from effecting amendments to the bill before finally passing it. These amendments do not necessarily have to agree with the views expressed by the people who have been heard, so long as the views have been taken into account. In our view, it would bring the legislative process to a complete halt and undermine Parliament's ability to discharge its constitutional mandate if, after having facilitated public